I want to start off by describing to all of our members, some of whom haven't been through this process, of what this consensus study process is that we're going through. In order for a league to take action, whether a local league, a state league, or the national, we need to have adopted a position on the topic. And the state league has a position on criminal justice, but it hasn't been updated in many, many years. And so they're in the process of updating their position. That will allow them to take action for legislation that is brought forward on criminal justice. And it would allow us also to take action, because without this in place, we cannot support particular kinds of legislation for reform of the criminal justice system. So that's the purpose of the study. League process requires that all of the local leagues have input into whatever that position is. And this is what we're doing here. We're gathering information for input into the state position. We have a couple of programs scheduled. We'll be sending you some emails with information as well on the questions that the State League has posed for us. We'll be sending the emails out and information regarding this process with the logo that Sarah Nixon has designed for us, the logo that you saw with the email invite for this program. So if you see that, you know it's going to be part of this process. This will culminate in a consensus meeting, maybe 2 in January, so that we can forward our results to the state. And this particular program is designed to provide information concerning questions that the league has posed concerning the pre-trial process. So I'd like to thank Dan Walsh, who has certainly a huge amount of experience as a professor, as a public defender, and other participating roles in the criminal justice system. And Deb, you want to introduce Dan?
Sure. Dan is our...
One more thing. Dan has said he's perfectly comfortable with questions during his presentation. So the easiest way is to sort of wave, and he'll be able to see you. Or you can put your question in the chat, and Kathy Hatch is watching the chat to make sure that the questions are relayed to Dan. So with that, turn it over to Deb.
So Dan graduated from the University of Illinois in 1973 with a BS in accounting. And in 1973 went to work for the Urbana Police Department as a police officer, where he worked until 1980. However, while he was working as a police officer, he also was attending law school at the University of Illinois and completed his JD and became a licensed attorney in 1979. From 1979 to 2002, he was in private practice and a managing partner with the law firm Johnson, Frank, Frederick, and Walsh, and worked in a myriad of different areas of the profession of law, which gave him a good background for his next step, which was in 2002, he was elected as the sheriff of Champaign County. Because of his exemplary background in both law enforcement and law, he was able to carry out the duties of sheriff in an excellent manner for the benefit of the citizens of the county. The sheriff is is a supervisor and employer of over 150 employees. He manages an annual budget of $12 million. He's responsible for 24/7 operations in both the operation of the county jail and law enforcement, which is all police work outside of the municipalities. We were fortunate in Champaign County that Dan ran 3 more times and was successful each time and served as our sheriff for 16 years. Since he retired in 2018, he has continued. He started as an adjunct instructor at the Police Training Institute in 1990, and he has continued doing that since his retirement, as well as returning to the practice of law with Johnson, Frank, and Frederick. I am sure that you will find what Dan has to share with us regarding the issue of criminal justice will be invaluable tonight. Thanks, Dan.
Well, I hope so. One correction, I'm back now with my old firm, but it's now called Frederick and Hagel. And if I didn't say that right, the boys would be mad at me. And what I'd like to do is give you a little history of Champaign County, and then we can talk about some of these various issues in the paragraph number 7 that you brought up. When I took office in 2002, well, the jail can hold, if you had the perfect mix, which you never, ever, ever do, the jail can hold about 300, 310 prisoners. Most jails are full when you reach 75 to 80% because you just can't put men and women together, you can't put different gang members together, et cetera. At that time, Judge Greg Townsend, who was a friend of mine, was the presiding judge, and John Pyland was the state's attorney. They kept locking up more and more people, getting tougher on crime. I went to them and said, you know, we don't have the room, and the county doesn't have the money to board out a county. Neither one of them cared. They said, that's not our problem. You go to the county board, find more money. And of course, then I had to deal with Miss Busey, and we all know how she is when it comes to giving the sheriff money. No, no, no. But no, she did a great job. Well, it became very problematic. We stayed in the high 200s, over 300 a couple of times between Judge Townsend and John Pyland. Well, Judge Townsend left. Judge DeFanis became the presiding judge. John Pyland left, and Julia Reitz became the state's attorney, and it was a whole new attitude. We went from upper 200s down to lower 200s, upper hundreds. Judge DeFanis took it on himself to help us. Every morning he asked us for the jail census, and his goal was to keep that census down. Of course, Julia was very reasonable. She helped us too. And I'll go so far as to say at one point, Judge DeFanis said that he would issue a order for the county, because he can do it as the presiding judge, that would basically allow me to act as the bond court judge on lower level felonies and misdemeanors. And I said, I can't do that because I don't have immunity like you judges do. If I make a mistake and somebody gets hurt, we can be successfully sued in the county. So I can't do that. But he really took it on himself to try to minimize our jail population, get people out of jail. The other thing that's different about our county, if I saw somebody in jail, or if my jail captain saw somebody who she didn't think needed to be there, we could call Julia. At one point she said, oh, just call DeFanis yourself and tell him you want to let this guy go. So they really work to keep our population down and to keep it so that the people in your jail really needed to be there. I called Carrie Bogus. She is the jail commander. She's a captain. And because of the COVID, the cops are making less and less arrests. Their population now is about 150. Every one of them is in there on felonies. Let me get to my numbers. She said virtually our population now is made up of gun violence people, people involved in sexual crimes, and other serious drugs. We now only have one person pending placement in DHS. When I was there, we had as many as 10 or 11 awaiting a bed at DHS. So COVID has changed things. Plus over the years, I think Dustin, the new sheriff, has always pressured the local departments, don't make a custodial arrest unless you have to. The other thing that's different about our county, and this is going now to your paragraph number 7. Long before I was sheriff, the county had a policy of doing a bond court almost every day. I think sometimes we skip Christmas, but otherwise bond courts every day. The public defender before COVID would go out to the jail and meet with the new intakes. With COVID now, they do it by phone or Zoom or something like that. But the advantage of that is then there was already counsel at the very first appearance when they're talking about bond. So the public defender could argue bond and say why this person doesn't need to be in jail, why they're not a flight risk, things like that. Anybody who came through our jail, we had to run the criminal history so the state's attorney would know what they're, not just what they're charged with now, but what their criminal history is. So we're very unique because we have bond court almost always the day after, or even if you're arrested at midnight or 1 a.m, most of the time you're going to be taken to court that same day. Julia's different. because in some counties, you sit there on the charges that the cops brought. The state's attorney may not seriously look at the case for anywhere from 1 to 2 weeks. So you're just sitting there. Julia has adopted a policy where virtually every day they have somebody going through our reports before they go to bond court. So they make a charging decision. So if we overcharged or undercharged, the state's attorney corrects it, and they set their course right there that very next day. It could be a Saturday or Sunday. That's unlike many counties. The other thing, and a lot of people don't believe me, we really work hard to keep the population down. And I don't remember the exact numbers. McLean County has got a population of around the same as we do. I believe before COVID anyway, their jail population was about 50% higher than us. Vermilion County has got a population much less than Champaign. Their jail population was almost double ours all the time. So we're a little bit unique. Some of these changes here that are proposed may make a noticeable difference in other counties' jail populations. I think it'll have a very minimal effect in Champaign County because all of the things that Julia and the judges have been doing. I'm assuming Judge Rosenbaum, who is now the presiding judge, will continue with Judge DeFanis's attitude and policies about don't put them in jail unless they really need to be there. Any questions on the history and where we're at? Okay.
I just want to say that I certainly appreciate the history of Champaign County, but one of the things that we would be looking to going forward is perhaps making the kinds of discretionary decisions that the judges and the state's attorneys make to be more institutional based on some legal requirements. And so maybe we're certainly ahead of many counties, but like it was with Greg Townsend and John Pyland, we don't want to have to depend on specific individuals in those institutional roles.
Okay. Well, in terms of bonding out, if we use some sort of scoring device or system like that as a primary goal, then there should be some uniformity throughout the whole state. But as you know, Trish, in terms of charging decisions, unless there's a change in the law, that's an absolute discretionary decision by the head state's attorney, what attitude they're going to take. And luckily, Julia is pretty reasonable. So the first question, should cash bail be abolished? Again, in Champaign County, I think it'll make very little difference. Throughout the state, it will make a difference. I think if we go to a scoring device of some kind and we pretty well try to get rid of cash bail, if we decide you are not a risk to the public, you are not a flight risk, and you're likely to show up in court, then I think that the jail populations will go down. As most of you know, the majority of a jail population is pre-trial. They have not been convicted of anything. The one thing that I noticed as I read through the Supreme Court stuff and as I read through this paragraph 7 issues, the one category of people that are not really addressed are the minor but chronic repeat offenders. And it's easy to say, well, it's not a serious crime. It's not a serious crime unless you happen to be the victim, and then it can be very serious. What do we do with the guy who, every other morning goes into McDonald's and urinates on the floor or disturbs everybody else or grabs people's coffee? Is it a serious crime? No, not really. Is he likely to flee the jurisdiction? No, not really. But what do we do when he keeps on doing it? And we do have people like that. Many of them do have substance abuse or mental health problems. Some of them are just jerks, or a combination. So that's the one category I noticed wasn't really discussed at all. And the cops and the jails and the judges need to be able to do something with that type of person. Again, well, who cares? Well, you care if you're the victim. You care if it's your business that's being disturbed. So as to the first issue, should cash bail be abolished? Again, I think that's not a bad idea. somebody here pointed out, I guess you guys did, League of Women Voters, that the county clerk makes money, I'm sorry, the circuit clerk makes money off of it, is they get to keep 10%. So that will be a loss of funds, and I really doubt if the state of Illinois is going to be able to give any more money to the counties. Should defendants be detained in jail only if they're a flight risk or a danger to society? I don't really have a problem with that, again, but we have to do something about the repeat minor offender because we can't let them keep disturbing and making victims, though it be lower level crimes. Should risk assessments be transparent? Right now, there's 30 some factors the judges look at. So, and they get information. For example, how long have you lived here? Do you own your own home? Are you working? How long have you been working? What are your other ties to the community? What's your criminal history? How many times have you failed to appear? And believe it or not, there's people with a history of failures to appear. So the judges, without using a scoring instrument, are pretty well trying to do that. The thing is that judge number one may view 3 failures to appear differently than judge number 2. The advantage if this thing includes all those factors and they get used to using it is now you can see what it is. It's more objective. Judge number 1 and judge number 2 are more likely to come up with the same result if you have an objective scoring device like this. So that's one thing. Slip my mind. Electronic monitoring. I personally think electronic monitoring is useless. It's a waste of time and money. If I want to flee the jurisdiction, I just cut it off. If I want to do bad things, I just cut it off, or I just do the bad things anyway. So I think that should rarely, if ever, be used. Now, we did use electronic monitoring as part of our home confinement. I do think home confinement is, of course, that's after sentence. I do think home confinement with electronic home detention is a good idea. Very few have cut it off. We have, I'll tell you this now, we have deliberately put drug dealers on electronic home detention after sentencing because part of the agreement is we can search their house and their person at any time. So we did that with a couple we thought were continuing to deal, and in fact, they were. Must the bond court judge review the public safety assessment that's the basis of the determination? Yes, we're going to have to figure out who's going to do this assessment. We discussed it in our county when Mr. Kalmanoff was here. And there was some discussion about having correctional officers do it, but there's just not enough time. You're going to have somebody who need to get somebody who's trained in this, and that's their job. So it's going to cost the counties or somebody, it's going to cost money to train people and to have them do this on literally a daily basis. Much of what they're going to have to do, you're not going to be able to verify by the first bond court, because bond court again is usually that very next day. So if I say I'm working at Solo Cup and I've lived in the community for 10 years and I've got 5 children I'm supporting, there's hardly any way to check that by the time you're arguing bond before the judge. Hopefully most people will tell the truth, but all of them don't. Should pretrial service providers remind defendants of court appearances? I believe right now that Katie's office has been doing that for a while. As helpful as Judge DeFanis was, when we broached that idea with him, he put the kibosh on it and said, no, court's important. These people ought to get to court on their own. We're not going to send them reminders. I think that has mellowed out since I've left, actually. And I believe Katie is sending reminders. There certainly are people who forget to go to court. They're irresponsible. A text reminder, an email reminder, a phone call probably would minimize a little bit the failures to appear. There are others that obviously just don't care and they're just not going to show. Should an attorney or public defender be present for all defendants at all hearings? I think that's a wonderful thing. That's what we've been doing in this county for decades. It does give the defendant a chance to argue his position or her position as to why they should be released on recognizance, or if we're going to use cash bail, have a very low cash bail set. I guess you guys know that recognizance is also used a lot, where the judge will set a bond, but I simply sign an agreement saying I'm going to show up. It's called release on own recognizance. If I don't show, the county could get a judgment against me for the amount of the full bond and try to collect it. As a practical matter, I'm not aware of that ever happening while I was in office, where they actually went after somebody who failed to show on a recognizance. Have I answered the questions, Deb or Trish?
Deb, I think you had some comments about the recognizance system and sort of its interaction with a cash bail, and how it really doesn't add anything to the process. Do you want to describe that?
Sure. If I'm given a $10,000 recognizance bond, I do not post any cash. I simply sign the bond saying I'll agree to show up. If I don't show up, then the court generally will issue a warrant. There'll be a hearing set on a motion to forfeit bond about 30 days down the road. I probably won't show up for that either. The bond is technically forfeited now. I owe the county $10,000, but I've never seen the county go back and try to collect it. Deb, are you aware of any times we did?
No.
No, I don't think so.
We worked on collections on unpaid, costs and fines and so on, but I don't think we ever pursued going. I mean, we had, if a bond had been posted, we had the forfeited money, right? The $1,000 on the $10,000 bond, and we kept
Right.
that, but we never went after the full bond.
Okay.
So it's more of a kind of a, what you might call an imaginary system. So if you abolish cash bail and instead of recognizance bonds with a set bail that isn't actually posted, you would just be released based on the factors of whether you constituted a risk to the community or a flight risk.
Right.
Yeah.
Now, there is one other thing, and this is, again, financial. I don't know if Debbie, you remember this, but shortly after I took office, we had a big drug dealer who failed to show up. His bond was cash of $250,000, if I remember right, and that was forfeited out to the county at a time when that $250,000 was very helpful, if I remember correctly.
Yes, you're right. Absolutely.
So there is a financial reason, especially I think when you're dealing with drug dealers, because a lot of them, you let them out, they're literally just going to go back to what they were doing. And when I'm talking drug dealers, I'm not talking the young people selling, on the street corner. I'm talking about the bigger organized things where they're really running a business enterprise.
Okay. But with your Zoom invite, there was also a copy of the slides that set out the questions, and you could look at those if you want to. And then there's a couple people who would like to be recognized. Minnie, you have to unmute yourself. You're still muted.
Okay, here I am. Okay, I've heard, can you hear me now?
Yep, can hear you.
Okay, great. A lot of assumptions are made here right now. I'm listening. We have done an extensive amount of work with the criminal justice system, Dr. Tom Moore and Dr. Janet Guthrie, and a number of people at the NAACP Champaign County branch. You hit on a couple of things about people who should not be in jail basically because they are mentally ill. That is not a place for a person who's mentally ill. So if you don't solve the problem, yes, it's going to be repeated. So with the reference of going into McDonald's and doing repeated this and repeated that, that person actually needs help. So to have that person running around continuing to do the same thing over and over again tells you that there is a mental problem and it's not a jail problem. People who are in jail possibly for certain crimes who cannot make bail, they're sitting there for I don't know how long, and they're not getting the representation or the help that they need. That is a problem within itself. I see it basically too as unfair, but that's another story. We can go into that deeply. But sitting there when they cannot make bond and provisions are not made, they're African American, people of color who do not have access to real good attorneys to represent their interests. There's a lot of racism involved in it because there are crimes all over the place. And to assume that if you do this, then they're going to do that, I think is pretty, you're making assumptions. And so,
Minnie, do you think that abolishing the cash bail would help that problem?
yes, and he did hit on that. So I would, I like the way that was going. Yes, absolutely.
And I agree with what Minnie just said about the mental health. No sheriff, no correctional officer wants those people in a jail. The problem is there's literally no place else, or at least there wasn't when I was in office. So the jail became the de facto mental health institution, even though it shouldn't, because there was just no place else.
So it's a problem that needs to be addressed sort of at the front end with alternative mental health services.
Yeah, remember we brought that guy in from Bexar County, Texas. I forget his name, and they've got a very extensive mental health service down there. Well, it's mental health and some medical, because they're trying to keep people out of the jail, but it cost them a ton of money. I think they had taxing power, didn't they, Deb?
Yes, they did.
Theresa, I think you had some questions.
Yeah, I wanted to ask about risk assessment. Does the state of Illinois have risk assessment tools that are mandated to counties, or is there a potpourri of risk assessment tools that can be selected? And how do those work? Because what I have read is that recently, I know ProPublica did a big thing on how these algorithms are actually quite prejudicial against African Americans. I don't know what the items in the risk assessment are. So anyway, my question is, how are they used here? What's mandated by the state? What do you think could change or should change?
There are none used here. There are none mandated by the state. I believe some of the counties on their own have picked up various risk assessments. The Supreme Court, when they talked about it, there were 3 of them that they found to be somewhat more reliable than others: Virginia, Ohio, and I forget the third one. Whether or not they're weighted against persons of color, I don't have any idea. I mean, you would hope they wouldn't be, but maybe they are. I can't answer that part.
So the risk assessment is just done by the judge with the defendant in front of him or her.
I think there are statutory factors the judge is supposed to consider. There's like 32 of them. So I think the purpose of a risk assessment tool is kind of to standardize the process, but it's a question of selecting the right tool so that there aren't inherent biases in the tool itself. And I think since attention has been directed to that problem, there are people who are working on trying to come up with a risk assessment tool that is not inherently biased. But as far as I know, there isn't one yet.
Yeah.
All right, any other questions? There's Ruth Mitchell. You're muted, so you'll have to unmute yourself. Okay, we can't hear you.
Sorry, is that better?
Yes.
Sorry about that. In terms of the assessment that you're just talking about, who actually sees that? I mean, is there a report after the assessment is done? I mean, I realize there's probably some level of confidentiality surrounding it, but
well, I don't think there's any confidentiality in the court process.
Oh, okay.
In
the assessment itself? Mm-hmm.
Well, there shouldn't be. I mean, it's a public proceeding.
Mm-hmm. And how does one see those? Or is that just on the public record, or?
Well, right
Matter of
now, we
public
don't
record.
have them. But what Trisha's saying, there are 30-some factors a judge is supposed to consider when setting bond. And all those are discussed in open court. You know, how long has Dan lived here? How long has Dan had his job? How many times has Dan failed to appear? It's all public record.
Mhm.
I don't think anybody keeps statistics, though, on each person where you could view it in writing. And like I said, we're not using risk assessments now, so there's nothing to look at.
Okay, thank you.
There are jurisdictions that are using those, are attempting to collect that data and then evaluate it against results, because the whole idea of a risk assessment tool is that if you evaluate the person and the risk assessment tool says that they are not a danger to the public or a flight risk, and you release them without any bond, you know, has it worked or has it not worked? And unfortunately, it can only work in the negative. Kathy?
I have a question from the chat room. The person, Jonna asks, you mentioned victims earlier. I am researching the question of sentences being tougher on those crimes that are committed with a gun or assault weapons. With victims in mind, I would think a knife or baseball bat would be just as scary as a gun. What are your thoughts?
It is, and the thing is, in our statute, the statutes elevate the various sentencing levels automatically if a firearm is used or certain other things happen. I'm above 60, and if I'm the victim of a battery, the sentence is worse than if they committed a battery on a person below 60. These are statutory guidelines the legislature put in there for the sentencing. And I would say there's dozens and dozens of these various enhancements depending on what type of weapon is used, who your victim is, things like that.
Okay, any other questions? Do we have Theresa?
I was just going to ask, are there other statutory, what do I want to say, judgments that have to be made? What I know as a sort of casual listener to the news was the difference in sentencing between crack cocaine and coke, the kinds of stuff the well-to-do were using, that the sentencing was way stricter, and those were kind of mandatory sentences, I guess. Are there those kinds of, does that still exist in Illinois? And are there other kinds of unequal, that have proven to be now sort of unequal sentencing guidelines that just haven't proved to be good for the community?
What you're talking about, the different types of cocaine, powder versus crack, I believe that was in the federal sentencing guidelines. I don't think Illinois has ever had anything like that. The other thing is federal judges have guidelines that used to be much stricter, where they had very little latitude in sentencing. That's been loosened up a little bit. Our state court judges have generally had and still have a broader range of sentencing discretion than the federal judges have.
Excuse me, this is Minnie Pearson again.
Sure.
When you talk, I know just a little bit about drugs. Basically, you know, most of my dealings with the criminal justice is through the work that's been done. When it comes to crack cocaine, that's usually African-American people of color. The charges are much harsher than it would be for a white collar, a corporate person to use cocaine. So it's a difference there. It is a big difference. The crack cocaine, they come down on them pretty hard. The powder cocaine, where it's used really heavily by the white community, but the charges are different.
I think there's also in addition to, you know, it's sort of separate from this case, from this bail and pre-hearing procedures questions, but I think there's certainly a total reevaluation going on about the efficacy and moral, sort of speak, weight of the war on drugs, and that there's a reevaluation going on as to whether, you know, this using the criminal justice system as a way of treating people who use drugs or sell drugs or whatever is certainly being very much reevaluated today, because it seems to be part and parcel of the kind of structural racism that's resulted in such a high rate of convictions by of African Americans. So I think it's all part and parcel of this movement to reassess the criminal justice system, and one of the reasons why we're having this program and the State League has raised these issues is that we're really seeing it in a different light, and we need to establish positions that we can act on to help forward these reform movements. Sarah?
Hi, Trisha. I just wanted to comment about trauma and the role that trauma plays, because some people have been touching on the issue of mental health playing a significant role in, you know, leading to people's involvement in the criminal justice system. And trauma, especially childhood trauma, and what we now know, or what is now called adverse childhood experiences, or ACEs as an acronym, plays a huge role both in the African American community and in the Caucasian community, in terms of even as a predictor of later in adulthood involvement with the criminal justice system. And I'm just trying to remember, are there any questions in our questionnaire that we're looking at? I'm just trying to remember, do any of them actually ask about trauma? And I apologize if I can't remember and it was really obvious, but if none of the questions do engage the issue of trauma, I would just like to remind us all to keep that, and especially if none of the questions address trauma, we should perhaps all be keeping that in mind as we approach these questions and try to get at answers. And just one more thought was, Sheriff Walsh mentioned something about a Texan community where apparently they were successful or doing good work in addressing the problem, as Trisha called it, from the front end. I would love to hear a little more about that. And did you say it was called Bear City or Bear County or Bear City? It sounds really interesting.
It's Bear County. It's spelled really odd. Deb, do you remember that guy's name?
I don't remember his name. Bear County is B-E-H-R, and I can't remember his name either.
Yeah.
Has Champaign County, what kind of efforts have they made in terms of providing mental health services to people as they get involved into the criminal justice system?
The jail itself, we have mental health counselors, but quite frankly, their goal is not a long-term cure. Their goal is to keep them safe while they're in jail and not let them deteriorate any further. Myself and Alan Jones and Peter Tracy, before the economy recently went bad, not recently, this a couple of years back, tried to get all the mental health providers together and the Carl Hospital and OSF to fund another program to try to deal with this on the front end. And we had meetings, and the economy wasn't good. People were getting laid off. That's when the state budget didn't pass. So the providers couldn't help us. Carl said, if we can put something together and get it running, then they might put some funds into it because it relieves the pressure on their ER, but they wouldn't put any funds into it until it was running. That's the other place where a lot of these people end up is ERs, which gets expensive too.
And Dan, didn't while Alan was there, wasn't there a specific special training for police officers for dealing with individuals who were in mental health crisis? And,
yes.
And on each shift. So that was another training initiative, and our local police departments engaged in that. And I assume they're still doing that to some extent.
I think they are. There's a 40-hour crisis intervention team that that many cops choose to go to, and a lot of that is 40 hours of mental health training. And then we all had, and I don't remember whether it was 1 day or a 3-day, I went to it, but I don't remember how long it was, mental health, the emergency training, if you will, and almost every cop went through that at least once. But that's no substitute for long-term counseling and psychiatric care, obviously.
In one of the ways that you know, we've gone backwards, I know when many years ago, when I had some interaction with the mental health system, that there was a mental health counselor on call to the police departments, and they could just call the mental health center and have a counselor sent out to the scene to handle a mental health issue directly. And you know, funding disappeared or whatever, and so then it just the mental health center couldn't handle the costs anymore, and it was then the ball was just dropped back to the police department, which is not where anybody wanted it to be.
I think Rantoul is doing that now, or they were when I left office. I believe they had 1 or 2 mental health counselors that were working daily with the police department and sometimes going on calls with them.
Yeah, but one of the other alternatives, of course, is the rest of the mental health system is not also very well set up to handle people. So each failure of the mental health system sort of cumulatively creates problems for everyone down the way. Sarah, did you have another question, or Kathy?
Just real quick, just the One Door project, just to mention that again, it is a pilot project in Urbana, but I guess they're trying it out and hoping to unroll it or roll it out in 2021 at some point. So, I mean, but it would be wonderful to see, to revive the attempt to have meaningful involvement from Carl and OSF and large institutions. It would be great to see that start up again. I think
we're having the mayors of Champaign and Urbana talk next month, December
9th.
What
9th.
What day?
December 9th.
December 9th, and hopefully Diane Marling can talk about this One Door project of this way of dealing with people at the front end. Barb?
I would be happy to, I was already going to add to question number 9 in the League's document about victims. And I would be happy to add this trauma just so we make sure we include it. But if anybody remembers another place in the document, because number 9 is only for younger people and trauma. And I agree with you, Sarah, it can be people above the definition of young people. But I don't remember if any place else in the document it is.
Can I say, I guess 3 things maybe. The Supreme Court talked about Class B and C misdemeanors in jail. You should never say never, but it would shock me if during my 16 years there was anybody sitting in jail on only a Class B or C misdemeanor. And I can tell you with absolute certainty that there was nobody sitting in jail just for smoking a joint. And a lot of people, that stuff is just not true. And obviously now marijuana is legal. So I noticed Judge Einhorn has joined us. Long time no see, Judge. You know, she's made hundreds of bond decisions. She was an extremely reasonable, easygoing judge, very even-tempered. You might see what Judge Einhorn thinks about these risk assessments, because she made hundreds of them without a device in front of her to do it.
You want to comment, Anne? You'll have to unmute
yourself.
Yeah.
Yeah, thank you, Dan. It's good to see you.
Good to see you.
Caution number 1, it's so many years ago now. And no, I never had a formal list at that time of factors. The one just knew that there were factors to consider. Obviously, failures to appear were major. I would absolutely agree with the sheriff. No, people didn't sit in jail for smoking a joint or for B or C misdemeanor. I think we forget that there's usually a history presented to the judge so that the judge is informed whether the person has failed to appear, the reasons they failed to appear, the kinds of charges they have accumulated. It is never as clear cut as the newspapers seem to present it. So
I do know the federal system doesn't have bail. It's the decision to hold someone in custody is made on the basis of, you know, we're going to hold them or we're not. So clearly other systems can do that without having bail as a guideline. Any other questions?
I just have a
One more.
comment.
Yeah, Minnie?
Yes, I have a comment. Because I'm at the age now, if I don't say it when it comes to my mind, geez. But anyway, when it comes to the police being able to the ability to handle mental illness or domestic violence or things like that, they don't have enough training for that. And so, Trish, when you said at one time they had a program where they would, you know, have a social worker or someone ride along with them or answer the call when something like that happened. I wish that we could get back to something like that because that's what is needed. The police should be able to, I mean, should be liable for the calls that are criminals, not mental illness and domestic violence and homelessness and things like that. So that's an extra strain. So that was one of the reasons why we were talking about not defunding the police, but reforming the police and giving some of those responsibilities to the agencies that are more equipped to handle that. For instance, when we go back to the Leah Lewis case in Urbana, it was obvious that she was clearly impaired when she was going through her rant and raving with the police and the incident, the whole thing, I won't go into it, but had a person who is trained in drug or mental illness or knowing that they're impaired by medicines or whatever, alcohol, could have de-escalated that situation and it would not have ended the way it ended. So the police does have a lot of responsibility to handle things that they're ill-equipped to do. So we really should be rethinking that part of the criminal justice system.
Kathy, do you have your hand up?
Yes, there's one more question for Dan. With resources for mental health, where would he see them directed as far as with criminals? In a perfect world, if we had unlimited resources, what would he do with them?
We would start with the first time we get called out on somebody who perhaps is committing minor crimes, but as Minnie said, you know, the cause is the mental illness or disease. So then get them hooked up with services, but it has to be somewhat intensive services. A lot of these people don't want it, so the provider would sometimes have to go to them multiple times. You know, and again, one of the problems is, okay, so I'm bipolar, I take my medication finally and I start feeling good and then I think I don't need it, so I go off my medication and the cycle unfortunately repeats itself. So they need to stay actively involved. The other thing, and I agree with what Minnie said, but everybody's got to realize this, the mental illness sometimes brings out some violence in people that otherwise wouldn't be violent. So it's oftentimes it's not a question of, well, we should send a mental health counselor instead of a cop. It's oftentimes, more often than not, I think the safe thing is we got to send a cop and a mental health counselor. So we're not saving money, we're spending more, but hopefully we get a better result in the long run.
Okey doke, any other questions? Well, I want to thank Dan for sharing his knowledge, and I want to alert all of you to keep an eye out for further emails involving our consensus study, and also that we will have another program on the consensus study question with the mayors of Champaign and Urbana. Minnie.
This is wonderful. Let me say that first of all. We need more dialogue and discussions in this area. So this is wonderful. And so thank you, Dan, for being here. It's not an attack. It's just, it's so much needed that we want to get everything in one session. So thank you so much. I appreciate it.
Well, Minnie, thank you. And ladies, I've enjoyed talking with you. I didn't take anything as an attack, and a couple of you I haven't seen in years. I hope you continue to do well, and it's nice seeing you again.
Okay. All right. I guess that's it. We'll see you we'll see you hopefully Friday for our virtual happy hour.
Good night, all.
Good night.
Good night.
Good night.
Thank you, Dan.